Thank you very much. Since our country is a lot younger than most of yours, I'll try to be short and be brief. I'm very pleased and honored to have the opportunity to speak to you today on the topic of judicial independence. My name is Stephen Anthony. The perspective I bring to this discussion is that of a practicing American lawyer who represents individuals and companies located around the globe. My clients' rights and interests are affected on a day-to-day basis by the legal systems of the jurisdictions in which they operate. I practice law in Washington, D.C. So you're hearing from another American, but let me tell you that I'm not a twin of Judge Marshall. He's a Republican, I'm a Democrat. He's a Southerner, I'm a Northerner. And he's a retired judge, and I'm a practicing lawyer. So my views may differ in some ways from Judge Marshall's. In preparation for this discussion, I considered how important it is to the clients, the real-world clients, individuals and companies around the world who I represent, how important it is to them to have access to an independent, fair, and efficient judicial system. And I considered the plight of one U.S. company that became involved in a civil case in a jurisdiction outside the United States. Also pending against it were criminal charges. Criminal charges were brought as well against individual members of the board of directors of the company. The judge and the prosecutors coordinated very closely with one another, and the criminal charges against individuals and the threat of arrest and detention of the individual directors became a lever in the negotiation of a civil settlement. And while the matter was resolved successfully, it was a matter of some years of charges pending over the heads of these individuals. So experiences such as this one have taught me as a practitioner to appreciate the value of judicial independence. It not only protects human rights, but also there are economic benefits as well. As Adam Smith recognized years ago, knowing that one can get a fair and impartial hearing fosters a business climate in which economic actors have enough confidence to make investments and engage in commerce, and this benefits society at large by leading to rising standards of living. So there are several ways in which the United States system, which is really the system with which I'm familiar, has long insulated judges from interference from political authorities, and I can tell you a little bit about those and my experience with those. Let me make clear, however, from the outset, that I offer my thoughts merely as examples of a way to accomplish judicial independence. I don't think for a moment that the United States system is the way to do it, or that the common law system is the way to do it. I think we ought to recognize that the U.S. legal system is just one of many examples to achieve the end of judicial independence, the objective of judicial independence. But it's the system I know, so I can tell you a little bit about it from my view, not as a judge, but as a lawyer who appears before and is occasionally victimized by the judges. So first of all, there's the separation of powers. There's the separation between the executive authority and the judiciary. And judges are not part of the executive branch. They're not part of the apparatus of gathering evidence and bringing charges against persons or entities accused of crime. And so whenever a judge decides whether to admit a piece of evidence, whether the charges are sufficient to go to a jury for a decision, or how to punish a criminal offender, for example, the judge is able to act free from any influence by the prosecuting authority. Now, our system was founded based on a rejection of the excesses of King George III of Great Britain, but the separation of powers is not merely a philosophical or abstract historical concept to people like me. It serves a practical and real-world effect in the 21st century. The fact that the judge is not on the same team as the prosecutors is critically important. For example, under our Constitution, a judge has to decide whether to issue a warrant based on a determination of whether the investigators have met the standard of probable cause. And the U.S. Supreme Court has ruled that such decisions need to be made by a neutral and detached magistrate who is not engaged in the often competitive exercise of ferreting out crime. Another function or another feature of our system is judicial tenure and guaranteed compensation. Under our Constitution, judges have protection from having their compensation cut or reduced. They have a specified term of tenure and can be removed only under specified procedures. And our federal system And my remarks are mostly focused on the United States federal system, although many states have similar principles of our 50 states embodied in different ways in their respective state constitutions. But at the federal level, under our Constitution, judges are appointed for life tenure, that their compensation cannot be diminished during their term in office, and they can be removed from office only for failure to abide by a requirement of good behavior, which Judge Marshall referred to, and that process requires a vote of the House of Representatives and then a 2/3 vote of conviction by the Senate. In historical practice, this standard of life tenure upon good behavior has been interpreted as permitting a judge to be fired only for grave misconduct. In the 228-year history of the U.S. federal judiciary, only 15 judges have been impeached, and only 8 of those have been convicted by the Senate. In the past 8 decades, there have been only 5 impeachments, each arising from gravely serious conduct such as criminal tax evasion, perjury, bribery, sexual assault, or obstruction of an official proceeding. So there's a high degree of independence there. As far as selection of judges, as I think Judge Marshall mentioned, the President of the United States nominates judges and appoints them by and with the advice and consent of the Senate. Those Senate hearings reviewing the qualifications of judges are held in full view of the public. That's a further safeguard to judicial independence. And on those rare occasions where the public has perceived that a president has tried to award a judgeship to an unqualified political ally, the resulting public outcry has caused such an embarrassment that the experience has resulted in a deterrent to future presidents for years. Another feature of our system that promotes judicial independence is the feature of transparency. Court proceedings in the United States courts are presumptively open to the public, with the exception of certain narrowly defined protections for sensitive matters such as trade secrets or juvenile justice or other matters that obviously should not be held in public. And this requirement of transparency is enshrined in our Constitution. Persons accused of crimes are entitled to be tried in an open and public trial under the 6th Amendment to our Constitution. In addition, as a separate and additional matter, the media and members, the news media and members of the public have, independently of the defendant, the news media and public have a right of access to the courtroom under the First Amendment. And all of this is sort of encapsulated in the judgment of the then future Supreme Court Justice Louis Brandeis, who once observed in extolling the value of public access to information, sunlight is said to be the best of disinfectants. So transparency is an important feature. And appellate review is another feature of our system that guarantees independence and corrects against error. In the US federal system and in many state systems, we have 2 levels of appellate courts above the trial court, although this can vary in some states. And what those courts handle and the functions of each respective court differ in reflection of their relative areas of competence. So, for example, in the federal system, a trial court's findings of fact must not be set aside unless clearly erroneous. And the reviewing court has to give due regard to the trial court's opportunity to judge the witness's credibility. The judge has heard evidence in person and seen and heard the witnesses in person. So there's a high degree of deference to factual findings of the lower court, unless the upper court has left with a definite and firm conviction that a mistake has been committed. On the other hand, as to matters of law, decisions of law are given by the lower court are given no deference by the higher court reviewing the decision when deciding what the law is. An appellate court will address such questions de novo, conducting its own legal analysis from the start. All of these features of our system and more, some of which are described in my paper, work together to mitigate the risk that our courts will yield erroneous results, either by accident or as the result of political interference. So a strong court system can contribute to confidence in business investment and enhanced personal liberty. Although our system has worked well for us, again, I emphasize, I don't pretend that the United States has figured out the only way to structure a judicial system. But what my experience as a practitioner has taught is that a system that's structured in a way that safeguards judicial independence is likely to inspire greater confidence in the work of the courts. Thank you.